The only way to end the COVID-19 pandemic is to vaccinate the entire world. Science tells us the higher the vaccination rate, the fewer chances the virus will have to acquire dangerous mutations. It is no wonder the Delta variant and now the Omicron variant have come into existence and led to further global outbreaks. Where was the Delta variant first detected? India, at a time where under 3% of the population had been vaccinated. Currently, Africa has the world's lowest vaccination rates, with only 7% of Africans having been fully vaccinated. And yes, Omicron was first detected in South Africa. Compare these vaccination rates with those achieved in Europe, the US, parts of Asia and Australia. Why is there such a disparity in the vaccination rates across the globe? There are many reasons for this, not just the way IP rights operate, but also how technology is transferred, if at all, manufacturing capability, supply chains, regulatory approval processes and so on. So what is the solution? Increased capability in manufacturing of vaccines and their equitable distribution in lower and middle income countries are crucial elements in any solution to this pandemic. The World Health Organization this year stated, "But it's not vaccines that will stop the pandemic, it's vaccination. We must ensure fair and equitable access to vaccines and ensure every country receives them and can roll them out to protect their people, starting with the most vulnerable." This is the point of the proposal submitted by India and South Africa to the World Trade Organization Council in October 2020. Commonly referred to as the TRIPS Waiver, the proposal seeks a temporary waiver of certain provisions of the Agreement on Trade-Related Aspects of Intellectual Property to remove existing intellectual property rights barriers that stand in the way of measures designed to make accessible the health technologies needed to fight the COVID-19 pandemic. Global manufacturing of vaccines and other COVID-19 related health technologies, together with expediting equitable access to such vaccines and technologies, are critical if the pandemic is to be brought to an end. This means ensuring that private monopoly rights, such as patents and other intellectual property rights, don't work against the greater good of ensuring the highest attainable standard of health as a fundamental right of every human being. The right to health is contained in Article 12, Paragraph 1 of the International Covenant on Economic, Social and Cultural Rights. This covenant requires states parties to take specific steps to achieve the full realisation of this right. Under Article 12, Paragraph 2, this includes, subparagraph C, the prevention, treatment and control of epidemic, endemic, occupational and other diseases. And subparagraph D, the creation of conditions which would assure to all medical service and medical attention in the event of sickness. Intellectual property rights are not absolute rights. They are granted and recognised by the state under the condition that they serve the public interest. For example, the object of the Australian Patents Act 1990 is found in Section 2A and states, "The object of this Act is to provide a patent system in Australia that promotes economic well-being through technological innovation and the transfer and dissemination of technology. In doing so, the patent system balances over time the interests of producers, owners, and users of technology and the public." It has always been a balancing act between these stakeholders, and this is also recognised in the TRIPS Agreement at Article 7. The protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare and to a balance of rights and obligations. And further, the principles in Article 8 of the TRIPS Agreement state, at paragraph 1, members may, in formulating or amending their laws and regulations, adopt measures necessary to protect public health and nutrition, and to promote the public interest in sectors of vital importance to their socio-economic and technological development, provided that such measures are consistent with the provisions of this agreement. And at paragraph 2, appropriate measures, provided that they are consistent with the provisions of this agreement, may be needed to prevent the abuse of intellectual property rights by holders or the resort of practices which unreasonably restrain trade or adversely affect the international transfer of technology. In 2020, we saw research laboratories around the world racing to develop a vaccine for COVID-19. In 2021, the issue of access to the variety of vaccines developed has been constantly in the press. Initially, the question was around the sharing of technology to hasten the development of vaccines and finding ways to ensure intellectual property rights don't hinder access to that technology. The Open COVID Pledge was one such initiative. Other examples include CTAP and COVAX. Now that we have several different types of vaccines, all the subject of patent rights, the question has moved to accessing the vaccines in a timely and equitable manner. Clearly, those that own the patent rights to the vaccines have the right to exploit their patents as they see fit. Or do they? This brings us to the issue of balancing the rights of the patent holder against the public interest. Patent rights provide creators of new inventions, like novel vaccines and medicines, with a limited term monopoly over those inventions in the marketplace to help recover the costs of research and development. In other words, patents are an incentive to invent or innovate. Patents are granted by individual nations but don't apply across borders. To gain global protection, an inventor needs to apply for patents in every country, something that could be critical when it comes to vaccines. The Patent Cooperation Treaty helps to streamline the process, but it is still expensive and time-consuming. The limited term monopoly on the market is balanced by the requirement that patent holders share information about their inventions in a register to make it available for anyone to use after the patent protection expires. The term of a standard patent is usually 20 years. During the patent period, patent holders have exclusive rights to manufacture and sell their inventions, or they can choose to license the technology to others to manufacture and sell to the public. Such licenses include a specified time limit and geographical area to exploit the patent. In return, the patent holder receives royalties or license fees, or both. So the race to develop a vaccine for COVID-19 was not just about saving lives during a pandemic, it's also about owning the patent rights. This gives the owner control over the manufacturing and distribution of the vaccine in the countries where the patent rights are granted. What has transpired under COVID-19 is a series of collaborations between private companies and publicly funded research institutions and universities, resulting in a thicket of patents and potential joint patent ownership. While this would give each owner the right to manufacture the vaccine, in other instances only together can they license the manufacturing to third parties. But even if patent ownership is in the hands of private companies, the state may still have the right to use them for its own purposes or in the case of emergencies. Many countries have specific laws to facilitate these arrangements. In the US, the Bayh-Dole Act 1980 ensures the government retains sufficient rights to use patents resulting from federally funded research. Under these rights, the government can be granted a free license to use the patent itself, or the right to arrange for a third party to use the patent on its behalf. In cases where the patent holder of a publicly funded invention refuses to license it to third parties, the Bayh-Dole Act gives the government march-in rights. Under specific guidelines, this means a forced license can be granted to a third party on reasonable terms. This includes in cases when the action is necessary to alleviate health or safety needs, or to ensure the patented invention is actually manufactured within a reasonable time. In the case of COVID-19 research, this means the US government could order a corporation or university that invents a vaccine with federal funding to license the patent to others to make it. In Australia, the government can exploit the patented inventions of others under right of Crown use. In these cases, the patent holder is entitled to financial compensation from the government. Like most other members of the World Trade Organization, Australia also has compulsory licensing rules in its patent law that force inventors to license their patents to third parties on reasonable terms in specific circumstances. In reality, though, such compulsory licences are underutilised in countries like Australia, New Zealand, the UK and Japan, and rarely granted, if at all. Such limitations on patent rights are provided in the TRIPS agreement and often referred to as TRIPS Flexibilities. These include Article 27.2 enables member states to exclude from patentability inventions in certain circumstances, such as for the protection of human health. However, that does not extend to preventing the patenting of pharmaceutical products. Only least developed countries have until 2033 to exclude pharmaceuticals from patentability. This should enable the development of genetic pharmaceutical industries or capabilities, as it has for India and Brazil in the past. Then we have Article 30, which enables member states to provide limited exceptions to exclusive rights conferred by a patent. Meanwhile, the TRIPS agreement provides for compulsory licensing under Article 31. Where compulsory licenses are granted by a member country, such licenses are subject to a series of principles that must be met, including the one found in Article 31F, limiting the utility of compulsory licenses to predominantly for the supply of the domestic market, authorising such use, thereby limiting export under licence by drug-producing nations to non-manufacturing, less developed countries. This led to the amendment of the TRIPS agreement, introducing Article 31 bis and the annex after Article 73, referred to as the TRIPS Protocol, which came into effect on the 23rd of January 2017. This amendment enables those countries capable of manufacturing generics, for example India and Brazil, to do so under compulsory licence and export to a least developed nation or other eligible importing member. Australia adopted the TRIPS Protocol in 2015 and is in a good position to assist its Pacific Island neighbours as a result. What has transpired is the phenomenon of COVID-19 vaccine nationalism, whereby low to middle income countries are still trying to access supplies of the COVID-19 vaccines, while high income countries argue about reaching 80% full vaccination. This is why the TRIPS waiver is so important and raises the question of what happens beyond the TRIPS waiver, which was always intended to be a temporary measure. It requires us to rethink global responsibilities to achieving the highest attainable standard of health as a fundamental right of every human being. The World Health Organization COVAX initiative, or voluntary licensing provisions, have not been successful, nor has the voluntary COVID-19 Technology Access Pool, or CTAP, of IP and know-how. Clearly, there needs to be investment in health technology capabilities in least developed nations, encouraging the development of generic pharmaceutical industries, as has been the case in India and Brazil. Only then can we hope to better deal with future pandemics.